so that they're best able to do their job of keeping us safe. And I know of many cases where DNA has been used effectively, both to catch dangerous criminals, rapists in particular. We hear cases like that all the time, and also to exonerate innocent persons, some of whom have been wrongly convicted. So I think DNA can be an extraordinarily valuable tool, and I believe we should arm our law enforcement officers with that sort of technology.
Great. I'm concerned about a lack of transparency in federally funded pretrial release programs. Individuals are often released without paying any bail on a promise to return to court and to meet the conditions of a pretrial program. If they fail to return or complete such a program, they become fugitives, and the taxpayers have to pay the price for billions in unpaid bills. Last Congress, I introduced the Citizens' Right to Know Act, which requires state and local governments that receive federal funding to report to the Attorney General on these pretrial release programs. What is your assessment of the pretrial release program?
Senator, I regret that I'm not familiar with those challenges. I know that in cases that I've supervised, we make every effort if we believe somebody poses a significant danger to the community to make sure they're detained prior to trial. And if somebody's eligible for pretrial release and they might be a candidate to be out in the community, then we would support that as well. But it's certainly important to make sure in either case that we have them available for court when the court date comes.
Thank you. Ms. Brand, you're here as part of the constitutionally prescribed appointment process. In that process, the President nominates but cannot appoint without the advice and consent of the Senate. We had a dispute a few years ago when the previous president attempted to appoint some officials without Senate consent. He tried to define for the Senate when we were in session and when we were in recess so that he could bypass the advice and consent requirement. In your capacity with the U.S. Chamber Litigation Center, you filed a brief arguing that the president exceeded his power under the Constitution. Am I right that the Supreme Court unanimously held that those appointments were unconstitutional?
Yes, Senator.
How important is it that the president abide by the limits of the Constitution, by the limits the Constitution sets?
Well, Senator Hatch, I think that it's important for every officer of the United States, whether in the executive branch, the Congress, or the judiciary, or in a regulatory agency, to stay within the bounds of the authority granted to them by the Constitution or laws of the United States. I think that divided governmental power, whether it's divided along federalism lines or whether it's divided horizontally with the separation of powers, is a critical protection of individual liberty and freedom.
Well, thank you. In 2008, you advocated against over-federalizing criminal justice. A growing number of experts and policymakers are also cautioning against over-criminalizing behavior. I've long been a proponent of a default mens rea, or criminal intent requirement in the Federal Criminal Code. What are your thoughts about a default criminal intent requirement?
Well, Senator, I understand that legislation along those lines has been introduced. I'm not sure if it's pending now, and I would have to study the details of the legislation. I certainly do think that it's important to have an appropriate, or at least a clear mens rea for every criminal provision in the code.
Well, thank you. That's all I have today. I appreciate both of you. Appreciate your willingness to serve. Appreciate the service both of you, each of you, has given to the federal government and to our fellow citizens in this country. Thank you so much.
Thank you.
Senator Leahy.
Thank you, Mr. Chairman. Ms. Brand, I do recall asking my staff to tell your child there was a place to be more interested in listening, even to your testimony, especially to the senators, the father and the grandfather. I understand that. Mr. Chairman, I know you said that you don't feel any need to invite the Attorney General back before the committee. I would note that his supplemental testimony last night did not even attempt to answer his misleading response to my question. And considering what the Russians appear to be doing to us, I do feel you should bring him back. Let me mention this. watch you both being sworn in, and over my years here, I've watched hundreds and hundreds of people being sworn in. It's a very important oath, and Mr. Rosenstein, you said you've memorized it. I'm sure you have. But many of the people who have testified so far this year as nominees, they've fallen short of this, and their misleading testimony only came to light after the press reported on it. Will you, I'll ask both of you, you can answer this yes or no. Will you commit to me that in the event you find a need to clarify any of your answers before this committee, you do so immediately and not wait until the press calls you on it? Mr. Rosenstein?
Thank you, Senator. I don't know if you've ever had the opportunity to be on my side of the table. We certainly make every effort to answer your questions fully
No,
and
but
truthfully.
the answer is, if you were to go back over it afterward, and witnesses have, and they found something in which we left this out, and they've let us know, will you commit to do that before you have to be forced to do it because of something in the press?
Yes, I would.
Ms. Brand?
Yes.
Thank you. Now, Senator Feinstein, Mr. Rosenstein asked you about the appointment of special counsel. I recall I was not in the Senate